Welcome to Module 4 of the July 2022 Title VI training for Nebraska Department of Transportation subrecipients and local public agencies. In this module, we'll be looking at Section 504 of the Rehabilitation Act and Americans with Disabilities Act requirements, and we'll also provide some links to example documents. For some background and context, prior to Section 504 of the Rehabilitation Act of 1973, disability had primarily been viewed as solely an individual medical issue. So in the medical model of disability, a physical or mental ailment is viewed as a biological dysfunction, and the individual treatment with a physician is considered the best approach to aid the disabled person. From a different perspective, the social model of disability seeks to eliminate systemic barriers, derogatory attitudes, and social exclusion, whether intentional or inadvertent, which make it difficult or impossible for individuals with impairments to function in our society. To say it a little more plainly, in the medical model, we seek to cure the individual so that he or she might participate fully in society despite the presence of barriers. But in the social model, we seek to remove the barriers. The social model distinguishes between impairments and disabilities. The word disability is used to refer to the restrictions caused by society when it does not give equivalent attention and accommodation to the needs of individuals with impairments. Section 504 of the Rehabilitation Act of 1973 is one of the first times that disability status had been recognized as a true civil right. Section 504 of the Rehab Act states that no qualified handicapped person shall, solely by reason of his handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity that receives or benefits from federal financial assistance. Section 504 applies to recipients of federal financial assistance. You'll notice that the language of Section 504 tracks very closely with the operative language of Title VI of the Civil Rights Act of 1964. Section 504 is still in effect. There are implementing regulations that we'll look at here shortly, but Section 504 has largely been superseded by the Americans with Disabilities Act. In the mid-1980s, the National Council on Disability began to push for more expansive disability protections than those found in Section 504, something more comprehensive that would fill in the many gaps left by Section 504. The concept had bipartisan support, and after several drafts, the Americans with Disabilities Act of 1990 was signed into law by President Bush. That's the elder President Bush. The ADA provided comprehensive direction for employers, public agencies, and private businesses in making their services and activities accessible for persons with disabilities. Next, I'd like to talk about some of the authorities and guidance that are relevant to the topic of disability non-discrimination. The disability rights, authorities, and guidance that we'll be looking at in today's training include Section 504 of the Rehabilitation Act, 49 CFR 27, which is the US DOT implementing regulation for Section 504, the 1990 Americans with Disabilities Act, 28 CFR 35, which is the US Department of Justice implementing regulation for the ADA, the 2008 Americans with Disabilities Act amendments, the 2010 ADA standards for accessible design, the manual on uniform traffic control devices, and finally, the public right-of-way accessibility guidelines. So to begin, Section 504 of the 1973 Rehabilitation Act. And I've read this language a time or two now throughout the 4 modules in this training, so I won't read the top section again. Section 504 does apply to recipients and uses very similar language as the Title VI regulations. And again, as I've said a couple of times, it's been mostly superseded by the ADA. It had a lot of the same requirements as the ADA for local agencies. The US DOT regulation at 49 CFR 27 implements Section 504 of the Rehabilitation Act. And as far as an implementing regulation goes, it is styled very similarly to the Title VI implementing regulation at 49 CFR 21 that we talked about in an earlier module. Like Section 504, this regulation has mostly been superseded by the ADA, but it does contain some requirements for recipients not found in the ADA or its implementing regulations, like, for example, requiring recipients to have signed assurances in the manner of Title VI. The Americans with Disabilities Act of 1990 is the flagship legislation in disability rights protection. The ADA applies to public entities rather than simply recipients, so compliance with the ADA is not tied to the receipt of federal financial assistance. The U.S. Department of Justice has the ultimate compliance authority for the ADA, but has delegated compliance and enforcement responsibilities to several other federal agencies, including the U.S. DOT. The U.S. DOT has in turn delegated to the Federal Highway Administration responsibility for ADA compliance in the public right-of-way and on projects using surface transportation funds. As with the Civil Rights Act of 1964, the Americans with Disabilities Act has multiple titles, but we're really only interested for today's training in Title II, which applies to public entities, state and local governments, and so forth. Title I requires employers with 15 or more employees to provide qualified individuals with disabilities an equal opportunity to benefit from the full range of employment-related opportunities available to others. I've found in these trainings over the years that some folks are more familiar with ADA in an employment context. But again, it's not really within the scope of our training for today. Title III covers businesses and nonprofit service providers that are public accommodations, privately operated entities offering certain types of courses and examinations, privately operated transportation, and commercial facilities. It might include things like restaurants, retail stores, hotels, movie theaters, recreation facilities, sports stadiums, and so forth and so on. The technical and programmatic accommodations under Title III are very similar to Title II, but again, it's not really within the scope of our training today. Title IV covers disability access to telecommunications, and then Title V of the ADA contains miscellaneous provisions, one of the most important of which is the prohibition on retaliation because someone opposes something that has been made unlawful under the Americans with Disabilities Act or participates in a discrimination complaint against an employer or a public entity or a public accommodation. The US DOJ regulation at 28 CFR 35 is the Department of Justice regulation implementing the Americans with Disabilities Act. This is a comprehensive regulation which provides much of the content of this module, many of the specific requirements for local entities or public entities, as the phrase is in the ADA. Together with the 2004 ADA accessibility guidelines, the regulations at 28 CFR 35 make up the 2010 ADA standards for accessible design. Since the passage of the Americans with Disabilities Act in 1990, several Supreme Court decisions had narrowed the scope of the ADA, and the ADA Amendments Act of 2008, sort of like the 1987 Civil Rights Restoration Act that we talked about in an earlier module, restored congressional intent for the protections of the ADA to be broadly interpreted and applied rather than so narrowly interpreted and applied. The most important update for the purpose of today's training is that the Act broadened the interpretation of the phrase any impairment that substantially limits one or more major life activities. The Supreme Court and the federal EEOC had set a high bar for meeting this standard, and this Act lowered the bar. Congress found that persons with many types of impairments, including epilepsy, diabetes, multiple sclerosis, major depression, or bipolar disorder, had been unable to bring ADA claims because they were found not to meet the ADA's definition of disability. And so following the ADA Amendments Act of 2008, an impairment need not prevent or severely or significantly limit a major life activity to be considered substantially limiting. The 2010 ADA standards for accessible design set minimum requirements, both scoping and technical, for newly designed and constructed or altered state and local government facilities, public accommodations, and commercial facilities. The 2010 standards contain most of the actual dimensions and other technical specifications for new construction or for ADA modifications to facilities. I've included the Manual on Uniform Traffic Control Devices as part of this Authorities and Guidance section, because in the time that I spent at the Nebraska Department of Transportation, I received a large number of questions about accessible pedestrian routes through construction zones, particularly when pedestrian traffic is going to be detoured or sidewalks or other pedestrian infrastructure will need to be closed for any period of time. I found the MUTCD enormously helpful in answering some of these questions. So be aware that if your agency has adopted the MUTCD, it works in conjunction with the ADA to require accessible routes through construction zones when pedestrian traffic is detoured. And a little later in this presentation, we'll talk about this in more detail. The Public Right-of-Way Accessibility Guidelines, or PROAG as they're sometimes called, are guidelines for physical access for elements located within the public right-of-way. The public right-of-way are the roads, sidewalks, and shared use paths controlled by a public entity. These are currently non-enforceable guidelines. They have not been adopted as official guidance or regulation, but the Federal Highway Administration considers the PROAG a best practice standard. And if nothing else, I found that the PROAG can help provide perspective in circumstances where the 2010 ADA standards are silent. which is fairly often when it comes to sidewalks and shared use paths. In the next few slides, just as we did in prior modules, it's helpful to review a little bit of Americans with Disabilities Act related terminology. A recipient under Section 504 regulations, just like under the Title VI implementing regulations, is any state or political subdivision or any public or private agency, institution, or organization, or any other entity to whom federal assistance is extended, either directly or through another recipient for any program. A public entity, on the other hand, under the ADA regulations, is any state or local government or any department, agency, special purpose district, or other instrumentality of a state or states or local government. A person with a disability is an individual who either has a physical or mental impairment that substantially limits one or more of his or her major life functions, or has a record of such an impairment, perhaps they once had an impairment but no longer have it, or is regarded as having such an impairment, maybe someone who appears to have a disability and therefore is treated or regarded as having a disability. A physical or mental impairment is any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more body systems. And there are a number of examples listed here. A mental impairment is any mental or psychological disorder, such as intellectual disability, organic brain syndrome, emotional or mental illness, and specific learning disability. Major life activities is a term with a very broad definition. It includes caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, sitting, reaching, lifting, bending, and a large variety of other life activities, some of which are listed here. Program access means that public entities must operate their programs so that when viewed in their entirety, they are readily accessible to and usable by individuals with disabilities. And so, for example, a public building, not every entrance to that building must be ADA accessible, but the programs that are operated out of that building, when viewed in their entirety, must be accessible by individuals with disabilities. Program access is achievable sometimes without physical barrier removal or structural modification. Now let's talk about specific responsibilities of public entities or recipients. This slide provides a kind of roadmap for the slides that are ahead. Some of the specific responsibilities of public entities or recipients are to develop written assurances, designate an ADA Section 504 coordinator, provide for public notification of ADA and 504 obligations, develop a complaint or grievance procedure, complete a self-evaluation, and develop a transition plan. Now you'll notice that a number of these items look very similar to the Title VI plan and limited English proficiency plan requirements from prior modules. A recipient must develop written assurances. Just like the assurances in the Title VI regulations, as a condition of applying for or receiving any federal financial assistance, a recipient must sign an assurance that the program will be conducted or that the facility will be operated in compliance with ADA or Section 504 requirements. There's not a standard assurance for this requirement as there is in the Title VI regulations. To meet this obligation, the Nebraska DOT essentially wrote a policy statement for its ADA assurance, which committed the agency to compliance with non-discrimination regulations. Any recipient or a public entity with 50 or more employees must designate an ADA Section 504 coordinator. The ADA coordinator coordinates the compliance of the public entity with the ADA requirements. The duties of an ADA coordinator will vary from agency to agency, but some of those duties may include collaborating and coordinating ADA and 504 compliance efforts with the heads of major divisions and departments, serving as a point of contact or a liaison to the public on ADA or 504 compliance issues, establishing and maintaining collaborative relationships with critical external stakeholders such as disability advocacy groups and other governmental agencies, monitoring the local agency's policies, procedures, practices, and processes for ADA and 504 compliance, identifying shortcomings in compliance and developing remedies, investigating and resolving complaints filed under the local agency's ADA or 504 grievance procedures, monitoring and updating the implementation of the LPA's ADA or Section 504 self-evaluation and transition plan, providing or coordinating the provision of requested auxiliary aids and reasonable accommodations to individuals with disabilities, and finally, performing ADA or 504 program, process, or compliance reviews, maybe inspecting facilities for accessibility. A public entity must provide public notification of its ADA 504 obligations. A public entity must inform the public that it will not discriminate on the basis of disability with respect to its programs, services, or activities. The public notice should identify the ADA coordinator, provide that person's contact information, and briefly describe how to go about filing an ADA-related complaint. Any recipient or a public entity with 50 or more employees must develop complaint or grievance procedures. Title II individual or class ADA complaints may be filed directly with the U.S. DOT or the FHWA. Under the ADA, complaints must be filed within 180 days of the most recent incident. Your complaint procedure under the ADA does not have to be a separate procedure from other civil rights related complaint procedures. For example, this and the Title VI requirements could share a complaint procedure, but there should be separate procedures for public complaints versus employee complaints. ADA complaints against the NDOT or against public entities that are not recipients are investigated by the Federal Highway Administration. ADA complaints against subrecipients are usually delegated to the NDOT for investigation. The investigating agency will be seeking voluntary compliance for violations. But if there is no voluntary compliance, it's very likely that the FHWA will refer the complaint to the Justice Department. Regardless of size, all recipients and all public entities must conduct an ADA self-evaluation. Public entities must examine all current policies, services, facilities, communications, and practices to determine compliance and the overall effect upon persons with disabilities. All public entities were to have completed a self-evaluation by January 26, 1993. An ADA self-evaluation identifies services, policies, facilities, and practices that are not accessible. There is a requirement to consult interested individuals and/or advocacy organizations during the self-evaluation. The self-evaluation should be updated on a regular basis, although there is no regulatory timetable for updating a self-evaluation. And if there are any physical or structural changes necessary, those must be listed in a transition plan. Self-evaluations are required to be kept on file for at least 3 years following completion. This is required for all recipients and for public entities of 50 or more employees. If structural changes are needed in order to be ADA compliant, a public entity with 50 or more employees must create an ADA transition plan. If structural changes are needed in order to make existing facilities ADA compliant, a public entity with 50 or more employees must create an ADA transition plan. For transportation purposes, we would expect to see items like crosswalks, curb ramps, and other accessible paths of travel in the public right-of-way contained in the ADA transition plan. The purpose of the ADA transition plan is to eliminate structural barriers to program accessibility in a public entity's buildings and facilities. State and local government agencies that have a responsibility for roads, highways, and pedestrian facilities must also have a curb ramp installation schedule. Though the FHWA's authority is to oversee public right-of-way and federal aid programs or projects, ADA transition plans should include all departments, services, and activities of a public entity. And so the ADA transition plan may include changes to the following types of facilities: headquarters, district, region, and field offices, rest areas, picnic areas, parks or historic sites, scenic overlooks, buses and commuter rail, airports, and pedestrian right-of-way facilities. Some best practices for ADA transition plan development are to appoint someone to coordinate plan development, implementation, and completion. This person will probably be your organization's ADA Section 504 coordinator. Determine if a self-evaluation and/or a transition plan have already been done, and build off of the existing documents if they do exist. Form a committee representing all applicable sectors of the organization to assist in this effort. Develop a procedure for installation of accessible facilities. Monitor the transition plan progress via milestones. Provide an avenue for citizens to request curb ramps and other accessible infrastructure. And finally, coordinate or incorporate the ADA transition plan with other plans like the pedestrian master plan or the bike pedestrian plan or your transportation improvement program. Next, I want to discuss a few additional responsibilities that don't quite fit into other categories. And so these are sort of various topics under the ADA and Section 504 for public entities. A public entity must take appropriate steps to ensure that communications with applicants, participants, and members of the public with disabilities are as effective as communications with others, including furnishing auxiliary aids and services when necessary. Examples of auxiliary aids and services include things like qualified ASL interpreters, note takers, computer-aided transcription services, written materials, telephone handset amplifiers, and assistive listening devices. A public entity or recipient would cover the cost of these auxiliary aids and services. It is generally acceptable for a public entity to require an individual to initiate a request for an auxiliary communication aid or service and give adequate notice that it's needed. The aid must be necessary, and a public entity can ask for medical documentation if the disability is not readily apparent. The public entity should give primary consideration to providing the aid that the individual requests, but it is not strictly required to give the aid that the individual requests, as long as the aid that is given is effective. Auxiliary communication aids and services do not include things like attendance or individually prescribed devices, readers for personal use or for study, or other devices or services that are of a more personal nature. The ADA requires that all new buildings and facilities constructed by a state or local government be accessible. Facilities or parts of facilities that are newly constructed after January 26, 1992 must be readily accessible and usable by individuals with disabilities. When an existing facility or part of an existing facility is altered, it must be made readily accessible to and usable by individuals with disabilities to the maximum extent feasible. Alterations to pedestrian facilities are required to be accessible as well. This includes sidewalks, curb ramps, and crosswalks. Once built, state and local governments must maintain the accessible features of facilities in operable working conditions. Poorly maintained facilities are not accessible or safe. Curb ramps are required when streets, roads, or highways are newly built or altered, or sidewalks, crosswalks, and paths are newly built or altered when they intersect roads. Curb ramps should be installed on existing facilities by way of a schedule and prioritization in your ADA transition plan. Kinney versus Jerusalem is a 1993 Third Circuit Court case where individuals with disabilities in the city of Philadelphia filed a class action against the Secretary of the Pennsylvania DOT and the Commissioner of the Streets Department of the city, seeking to require the city to install curb ramps on all streets that have been resurfaced since January 26, 1992. The Third Circuit Court of Appeal decision upheld the district court decision that resurfacing of a street is an alteration that requires a public entity to install curb ramps. Curb ramps are required to be added to an existing facility when there are alterations, but not when there's simply maintenance. So alterations include the addition of a new layer of asphalt, reconstruction, concrete pavement rehabilitation and reconstruction, open graded surface course, microsurfacing and thin lift overlays, cape seals, and in-place asphalt recycling. Treatments that serve solely to seal and protect the road surface, improve friction, and control splash and spray are considered to be maintenance because they do not significantly affect the public's access to or usability of the road. I've included a link on this slide to the US DOT, US DOJ Joint Technical Assistance on Curb Ramps, which provides additional information on what these agencies consider to be alterations versus maintenance. When adding curb ramps to your ADA transition plan, compile an inventory of locations, streets, and intersections to be made accessible, and then prioritize the locations that need to be modified, with the highest priority being the locations of government services, City Hall, schools, and hospitals, and the lowest priority being areas such as residential areas that are not locations where public accommodations and government services are provided. This is a very rudimentary example, but at least it helps you visualize the prioritization of curb ramps within an ADA transition plan. This is a simple example of that kind of prioritization. Occasionally, the ADA regulations recognize that it is technically infeasible to make something 100% compliant with the ADA regs. And so for new construction, it might be because it's structurally impractical due to the terrain. For alterations, it may be a change that would jeopardize the structural integrity of the facility. For historical sites, it could be something that would threaten or destroy the historic significance of the building or facility. The rule for technical infeasibility is that the public entity must still provide an alternate access route, accessible services, or accessible facilities to the maximum extent feasible. And it is extremely important to document all exceptions, decisions, and requests having to do with technical infeasibility. Public entities do not need to take actions that would result in a fundamental alteration to a program or an undue financial or administrative burden, or something that would destroy the historic significance of a historical site to achieve accessibility. But as with technical infeasibility, it's exceedingly important to always document these determinations. Path of travel alterations disproportionality is the only place where cost becomes a factor in an ADA analysis. This is a very limited exception. It's not broadly applicable to accessible facilities or accessible programs in general. When alterations are made to provide an accessible path of travel to an altered part of a facility, they will be deemed disproportionate to the overall alteration when the cost exceeds 20% of the cost of the alteration to the primary function area. Now, just a few slides on the manual on uniform traffic control devices. So, if a temporary traffic control zone affects the movement of pedestrians, adequate pedestrian access and walkways shall be provided. If the temporary traffic control zone affects an accessible and detectable pedestrian facility, the accessibility and detectability shall be maintained along the alternate pedestrian route. So what this section of the MUTCD is talking about is changing the pedestrian route during construction. When an existing pedestrian facility is disrupted or closed or relocated in a temporary traffic control zone, the temporary facilities shall be detectable and include accessibility features consistent with the features present in the existing pedestrian facility. Where pedestrians with visual disabilities normally use the closed sidewalk, a barrier that is detectable by a person with a visual disability traveling with the aid of a long cane shall be placed across the full width of the closed sidewalk. If establishing or maintaining an alternate pedestrian route is not feasible during the project, an alternate means of providing for pedestrians may be used, such as adding free bus service around the project, or assigning someone the responsibility to assist pedestrians with disabilities through the project limits. And in NDOT, we've had this happen on a couple of projects. We added a free bus service around the project when there was no reasonable alternate mean for providing accessible pedestrian access around the project. Whenever it is feasible, closing off the work site from pedestrian intrusion might be preferable to channelizing pedestrian traffic along the site with temporary traffic control devices. But then again, maintaining a detectable and channelized pedestrian route is much more useful to pedestrians who have visual disabilities than closing a walkway and providing some sort of audible directions to an alternate route, which might involve additional crossings and then a return to the original route. Jersey barriers, or wood or chain link fencing with a continuous detectable edging can satisfactorily delineate a pedestrian path. Tape, rope, or plastic chain strung between devices, warning tape strung between orange barrels, these do not comply with the design standards in the Americans with Disabilities Act accessibility guidelines, and they should not be used as a control for pedestrian movements. And I've both seen it and had it suggested to me as a compliant design for a channelized walkway for pedestrians, and it is simply not. Do not string plastic tape between barrels and expect that to work for an accessible pedestrian walkway in a temporary traffic control zone. In this slide, I've just included a link to the Manual on Uniform Traffic Control Devices, Chapter 6, which is where much of the information on the prior slides came from. Finally, we'll just summarize a few things that we reviewed in this ADA module and just sort of hit the highlights again before we say so long. A public entity must not discriminate against qualified individuals with disabilities. A public entity must maintain accessible features and provide equal access to programs and services. A public entity must also not discriminate in employment. A public entity may not refuse to allow a person with a disability to participate in a service, program, or activity simply because the person has a disability. A public entity or a recipient must provide programs and services in an integrated setting unless separate or different measures are necessary to ensure equal opportunity. A public entity or recipient may not create requirements that tend to screen out individuals with disabilities, such as requiring a driver's license as the only acceptable means of identification. A public entity or recipient is required to make reasonable modifications in policies, practices, and procedures that deny equal access to individuals with disabilities unless a fundamental alteration in the program would result. Finally, a public entity must furnish auxiliary aids and services when necessary to ensure effective communication unless an undue burden or fundamental alteration would result. Examples of auxiliary aids and services include note takers, interpreters, readers, video text displays and captioning, assistive listening devices, and telecommunications devices for the deaf. A public entity, however, is not required to provide individuals with personal aids or services, wheelchairs, personal attendants, things of that nature. I've included a link here to an example ADA policy and transition plan. In fact, these are the Nebraska DOT's ADA policy document and transition plan. Within the transition plan, you'll see a description of how the NDOT prioritized its curb ramps and also a typical example of a curb ramp schedule. If you have any questions on the information in this module, please feel free to contact me at the information that's provided on this slide. You can also contact the Nebraska DOT Civil Rights Office. Their contact information is located on the first slide of this module. Thank you.